Hello guys, my name is Amaan and I'm pursuing a third year's law, 3 years law from Delhi University, and I'm in third semester and I'm an intern at LEXIS and Company. So the topic of my today is to talk especially about the concept of anticipatory bail in India, which is given in section 438. So generally, a bail is of two kinds, that is regular bail and anticipatory bail, and the regular bail can be given by a court of a lower stature, but the anticipatory bail can be given by only a court of high court, only a high court and a court of session. So the Bail Act has provided us with a special heading that only a high court and a court of session can only provide the anticipatory bail. So the section 438 of the CRPC in 1973 talks about is a direction for grant of bail to the person apprehending arrest. So the keyword is apprehending. So the person has not been arrested yet, but he thinks that he is going to be arrested due to have any charge which he thinks is malicious or fabricated or false. So he can, if he can prove this malicious or false charge in the court, that he is going to be arrested due to it, and he has not actually committed the offense, he will be granted a bail. So section 438 of CRPC deals with the provision regarding anticipatory bail. The word anticipatory bail have not been defined in this code. The expression anticipatory bail is a misnomer and order becomes operative only on the arrest. Section 438 of the code treats as under like direction for grant of bail to a person apprehending arrest. So as I've already reiterated this concept. So where any person has reason to believe that he may be arrested on accusation of having committed a non-bailable offense, he may apply to the High Court of Court Session for a direction under the bail that any event of such arrest he shall be released of bail, and the court may, taking into the consideration the following factors, like for example the nature and the gravity of the accusation, the antecedents of the application, if he has been a good citizen in the past, or if there is any criminal charges against him in the past. So the court will see these, including the fact as to whether he has previously undergone imprisonment or conviction by the court in the respect of a cognizable offense. The possibility of the applicant to flee from justice is also seen, and where the accusation has been with the object of injuring or humiliating the applicant by having so arrested, either reject the application forthwith or issue an interim order for the grant of anticipatory bail. So the court will see if there is any merit, because it will the court try to protect the personal liberty of the person. So this is a very good provision which has been given in the CRPC for the personal liberty of a person, provided that where the High Court, or in the case maybe the Court of Session, has not passed any interim order under this section. If it has already passed an interim order in this section, this section cannot be used, or has rejected the application for grant of anticipatory bail, it shall be open to the officer in charge of the police station to arrest without warrant the application on the basis of accusation apprehended in such application. So a past interim order has to be also be seen before issuing an order under section 438 of the CRPC. So some other conditions that are specifically required in the anticipatory bail, which are not required in the regular bail, are the court will see is, for example, the person consent will have to make himself available for the interrogation by the police. The person will sign it that he will always be available and he will not flee from the country, and he will be made available to the police in the given time that is to be decided, and he shall not make any direct or inducement, threat or promise to any person acquainted with the facts of the case, and he will not leave the country without the primary permission of the court. So usually he cannot leave the country, because usually in a high profile cases the court centers the passport of the person, and so that is why these are some advanced conditions that are imposed for the person, that he cannot flee from the hands of the justice. So the condition requiring bail in India are that the provision was incorporated as per the recommendation of the reports of the 41st Law Commission. There should be an element of apprehension, either person seeking the bail feeling that he must be framed or arrested in a false case, or someone having enmity with him will try to get him arrested on the pretext or on a fabricated charge. The applicant has to present before the court certain special facts or circumstances which make him believe would result in his arrest. This is, however, left to the satisfaction of the court, where such facts which would be considered enough for granting of this bail. So you all may be thinking that this section is very wide and very big powers are given in the hands of the court to grant a person. The court may use it arbitrarily. So no, there are checks and balances, and as I've already mentioned, this power is only given to Court of Session and the High Court. So these are senior court presided over by senior judges who have proved their matter before the courts and their judgments. So these are senior judges, so they will not misuse this section that the Bail Act assumed so. So that is why these such wide powers are given to the these higher courts. So the object of this anticipatory bail, if we can, one can summarize this, that the right of liability and personal liberty, right to life and personal liberty is an important right granted to all citizens of the constitution. It is one of the precious right. The legislative history of the provision reveals that the Joint Select Committee of the Parliament had initiated a thought that bail should be made available in anticipatory of arrest so that the liberty of individual may not be unnecessarily jeopardized. If then it is then asked that Law Commission of India to take into consideration this matter, and the section has been added as a result of this report. So no person should be confined in any way until and unless held guilty, as it is conflict with the very nature of the right of life and personal liberty and also the natural right. So it is a famous slogan also that it is better than 10 guilty person escape than one of the innocent suffer. So the court is very much careful about the situation. If a non-guilty person is being arrested and he is even made to spend 1 day in the judicial custody or jail, the act does not want that. So it is clearly shown in these sentences. So the cancellation of anticipatory bail. So though there is no specific provision in section 439 regarding cancellation of bail, it is implicit the court which grants anticipatory bail is entitled upon appropriate consideration to cancel or recall that order. So anticipatory bail is a special privilege granted to the person apprehending arrest, and it shall not be abused in any manner. Even in the absence of express provision of cancellation of bail in this court, the power of cancellation springs from the overriding inherent powers of the High Court and can be invoked in exceptional cases only then when the High Court is certified that the end of justice will be defeated unless the accused is committed to custody. So the word exceptional use has not to be equated with the concept of sparingly used. So in the recent case laws also, many judgment of the Supreme Court also, it has been stated that the exceptional point should not be considered sparingly, because if the act is giving you such power, so you should use it. You should protect the liberty of the visual, and you cannot deny it and on any ground that this power is only exceptional. Like for example, the death penalty in Bachchan Singh case that was given, that is an exceptional power and only should be used sparingly. So this is not the concept of this is a special power. Obviously it is given to the higher court, in the hands of higher courts, the court of session and the High Court. So but should not be used sparingly, it should be used judicially. uh, so that's all I want to say upon the concept of anticipatory bail. So please remember, this video does not violate any guidelines of our Council of India and does not solicit or promote any of the advertisement, and sole purpose is educational. And guys, please subscribe to this channel if you haven't already to see more of this content in future, and I'll be coming up with the next video soon. And please do provide a feedback to this video, that helps us a lot. Thank you.